Yeah, you know what time it is. Disclaimer, I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice. And may you be blessed on your journey to find your power within these laws. Peace and blessings. Thank you for joining me. I've been receiving a lot of questions about what actions we have available for us as consumers to take against these deceptive and unfair practices that these corporations are doing against us. Well, in most of our contracts, there are arbitration clauses. A lot of us don't read the contract, so we don't know this, and we're not really even aware what arbitration is. So with that in mind, I wanted to go ahead and do this little video about it to maybe help give clarity and better understanding of the options we have to fight back against these people. All right, so I already have pulled up here arbitration definition. This is Cornell law. Arbitration. Arbitration refers to an alternative dispute resolution method where the parties in dispute agree to have their case heard by a qualified arbitrator out of court. Under the Federal Arbitration Act, decisions reached through arbitration are binding just like a court case is, and pursuing a claim through arbitration precludes you from also raising it in the traditional court system. Arbitration is used because it is often much less expensive than litigation due to its less stringent procedural requirements. Of the potential alternative dispute resolution methods available, arbitration is the most similar to taking your case to court. For example, while arbitrators are not subject to the federal rules of evidence, they nonetheless allow the parties in dispute to enter evidence when they deem it fair. Furthermore, parties undergoing arbitration typically agree to conduct some limited form of discovery. In recent times, arbitration has become controversial due to the widespread use of mandatory arbitration clauses. Under these clauses, parties contracting with each other agree to submit any future dispute to arbitration rather than a court of law. These clauses are often included within contracts of adhesion and are therefore prerequisites to employment. As a result, many people have raised questions regarding whether the constitutional right of employees to a trial are being infringed upon. Nonetheless, the Supreme Court has upheld the validity of mandatory arbitration clauses on multiple occasions. Notably, the Federal Arbitration Act does not apply to seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. This exception applies regardless of whether the worker is considered an employee or an independent contractor. All right. Now, so this gives a very good breakdown on the purpose of arbitration and what's been going on currently on how it's kind of becoming more of a go-to strategy. All right. Now, let's take a look at this. All right, I have pulled up here Federal Arbitration Act. Okay, let's take a look at this here. Title 9, U.S. Code, Section 1 through 14 was first enacted February 12th, 1925. All right, codified July 30th, 1947. Then it was amended September 3rd, 1954. Chapter 2 was added July 31st, 1970. Two new sections was passed by Congress in October of 1988. And renumbered on December 1st, 1990. Chapter 3 was added August 15th, 1990, and Section 10 was amended on November 15th. So we see they have made changes and updates to this document, but it still prevails. All right, Chapter 1 is just general provisions. Section 2 is maritime transactions and commerce defined exceptions of operation of title. Section 2 is validity, irrevocability, and enforcement agreements to arbitrate. Section 3, stay of proceedings where issues were therein referable to arbitration. They have Section 4 for the failure to arbitrate under the agreement, petition to the United States court having jurisdiction in order to compel arbitration. I myself just used this. I had to file a civil lawsuit against a bank because they were refusing to arbitrate, which is part of the contractual obligation. So I found it was very funny that they would dare to do that, and the judge did rule in my favor. I will be dropping a video with more details on that later. All right, notice and service, therefore hearing and determination. Section 5, appointment of arbitrators or umpire. Application heard as motion. 7, witness before trials, and yada 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 yada. You can see that. Now I want to get to reading some of this. I don't want to take up too much time. All right, Section 1, maritime transactions and commerce. Define exceptions to operation of title. All right, so we have maritime transactions as herein defined. Means charter parties, bills of lading of water, carriers, agreements relating to wharfage, supplies, furnished vessels, or repairs to vessels, collisions of any other matters in foreign commerce, which, if the subject of controversy, would be embraced within admiralty jurisdiction. Commerce, y'all. Commerce. Everything we do in America is commerce, so we're always within their jurisdiction. As herein defined, means commerce among the several states or with foreign nations or in any territory of the United States or in the District of Columbia, or between any such territory and another, or between any such territory and any state or foreign nation, or between the District of Columbia and any state or territory or foreign nation. But nothing herein contained shall apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. Sorry, guys. All right, Section 2, validity, irrevocability, and enforcement of agreements to arbitrate. A written provision in any maritime transaction or a contract evidencing a transaction involving what? Commerce, to settle by arbitration a controversy thereafter arising out of such contract or transaction, or the refusal to perform the whole or any part thereof of an agreement in writing, to submit to arbitration an existing controversy arising out of such a contract, transaction, or refusal shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. All right, Section 3, stay of proceeding, where issue therein referable to arbitrate. In any suit or proceeding be brought in any of the courts of the United States upon any issue referable to arbitration under an agreement involving for such arbitration, the court in which suit is pending, upon being satisfied that the issue involving in such suit or proceeding is referable to arbitration under such an agreement, shall, on application of one of the parties, stay the trial of the action until arbitration has been had in accordance with the terms of the agreement, providing the applicant for the stay is not in default in proceeding with such arbitration. All right, y'all. So if you have a claim against you and you have a good chance of winning, meaning you have an actual good grounds and proof that the claim against you is bogus, you can compel for arbitration when these companies file lawsuits against you. Now, most attorneys wouldn't advise for you to file for arbitration in the event you have a claim against you. More so, the plaintiff, they say, should file against you, and you should ask them to. All right. Now, if you have a valid claim, you can file for arbitration, and in their laws, it states you do not have to be an attorney. All right. So let's keep going. Failure to arbitrate under agreement, petition to the United States court having jurisdiction for order to compel arbitration. This is what I used in my case for the order to compel arbitration, and I received it. It was granted. Notice and service thereof, hearing and determination. A party aggrieved by the alleged failure, neglect, or refusal of another to arbitrate under a written agreement for arbitration may petition any United States District Court which, save for such agreement, would have jurisdiction under Title 28 in a civil action or in abnormality of the subject matter of a suit arising out of the controversy between the parties, for an order directing that such arbitration proceed in the manner provided for in such agreement. 5 days notice in writing for such application shall be served upon the party in default. Service therefore shall be in the manner provided by the Federal Rules of Civil Procedure. The court shall hear the parties, and upon being satisfied that the making of the agreement for arbitration or for the failure to comply therein is not an issue, the court shall make an order directing the party to proceed to arbitration in accordance with the terms of the agreement. See, that's very important, because a lot of times we don't realize that the same contracts that they're trying to enforce upon us have an arbitration clause in there. So they cannot pick and choose what terms of the agreement that they're going to try to enforce and not enforce. So if you have arbitration in your agreement, I strongly suggest you seek to invoke that, especially if you have great grounds and evidence that you are not guilty of what they're trying to allege that you are. All right. The hearing and proceedings under such agreement shall be within the district in which the petition for an order directing such arbitration is filed. If the making of the arbitration agreement or the failure, neglect, or refusal to perform the same be in issue, the court shall proceed similarly to the trial thereof, if no jury trial be demanded by the party alleged to be in default, or if the matter in dispute is within the admiralty jurisdiction, the court shall hear and determine such issue. Where such an issue is raised, the party alleged to be in default may, except in cases of admiralty, on or before the return day of the notice of application, demand a jury trial of such issue. And upon such demand, the court shall make an order referring the issue or issues to a jury in the manner provided by the Federal Rules of Procedure, or may specially call a jury for that purpose. If the jury find that no agreement in writing for arbitration was made, or that there is no default in proceeding thereof, the proceeding shall be dismissed. If the jury find that an agreement for arbitration was made in writing and there is a default proceeding thereof, the court shall make an order similarly directing the parties to proceed with the arbitration in accordance with the terms thereof. So there you have it again. They're just pretty much hammering down on the fact, if you have this in your contract, all right, please pull your contracts out and look. If you have this, then this is your first course of action you want to take. And I'm pretty sure your contracts have some type of violation that you can go ahead and invoke through arbitration. All right. Now it's the point of arbitration. We're not going to get all of that. I just wanted to show you this so we can go ahead and get moving on. So now let's go to and check out some examples, shall we? Right, so I have pulled up here a Credit Union of Texas binding arbitration consent and agreement for consumer loan note and disclosure. All right, binding arbitration consent and agreement. You and we agree to attempt to informally settle any disputes arising out of, affecting, or relating to your loan with us. If that cannot be done, you and we agree that any claim or dispute between us based on conduct, activities, actions, or omissions that occur on or after the effective date defined below of this binding arbitration consent and agreement, and which arises out of or relates to this note or your loan, shall, at the election of either of us, be resolved by binding arbitration administered by the American Arbitration Association in accordance with its applicable rules and procedures for consumer disputes rules, whether such claim is in contract, tort, statute, or otherwise. The rules can be obtained on the AAA website free of charge at www.adr.org, or a copy of the rules can be obtained at any credit union store upon request. As a result, if either of you or we elect to resolve a particular claim through arbitration, you will give up your right to go to court to assert or defend your rights under this agreement, except for claims brought individually within the justice court jurisdiction, so long as the claim remains in justice court. This binding arbitration consent and agreement will be interpreted and enforced in accordance with the Federal Arbitration Act in Title IX of the U.S.C. Code to the fullest extent possible, notwithstanding any state law to the contrary, regardless of the origin or nature of the claim. The Texas Arbitration Act will not apply to this binding arbitration consent and agreement or to any claim between us. You acknowledge that this binding arbitration consent and agreement does not prevent you from submitting any issues relating to your account for review or consideration by a federal, state, or local government agency or entity, nor does it prevent such agency or entity seeking relief on your behalf. By consenting to binding arbitration, you understand and agree with the following terms: the selection of the arbitrator, the effective date, claim arising prior to the effective date, arbitrating proceedings, this is the manners in which it goes, the class action waiver, location, cost. You understand we will pay for any filing, administration, and arbitrator fees as imposed on you by the AAA as of $75,000 or less, provided the claim is unrelated to debt collection. Otherwise, arbitration fees will be allocated according to the applicable rules. If we prevail, we will not recover our arbitration fees from you unless the arbitrator decides your claim was frivolous. Attorney fees, severability, survival, amendment/termination. You got the right to opt out. You have the right to opt out of this binding contract. So I had the right to opt out of this, but I would have had to done it. Let them notify my intentions to opt out within 60 calendar days after we provide you this binding arbitration consent and agreement when your loan is funded. Well, my loan technically never got funded, but anyway, your opt-out is only effective if you notify us in writing to the Credit Union of Texas attention, Member Service Department, All right, so we see this here, y'all, live in full effect. All right, let's go to another example. I have another one pulled up here. This is, okay, so this was a loan from a company called Lightstream, and on their document, as you see, okay, truth of lender, they try to give me disclosure, all right, the finance charge, blah blah, all right, what is it, $45,000, and I was gonna pay back $55,000. But the problem with this is this document failed to contain the required notice that it was supposed to have, which is the holder in due course rule, which I speak about in one of my previous videos. So I got them on that, and we go down here for arbitration. Boom, right here, arbitration provisions. Read this provision carefully, as it will have a substantial impact on how disputes and claims you and we have against each other are resolved. Well, thank you. This arbitration provision does not apply if, as of the date of this agreement, you are a covered borrower under the Federal Military Lending Act. Okay, if you would like more information about whether you are covered by the Military Lending Act, in which case of this arbitration provisions does not apply to you, please contact this number. All right, you have the right to reject this arbitration as set forth below. If you do not reject this arbitration provision for a claim subject to arbitration, neither you or we have the right to: 1, have a court or a jury decide the claim; 2, engage in information gathering, which is discovery, to the same extent as in court; 3, participate in class action in court or in arbitration; or 4, join or consolidate a claim with claims or any other person. The right to appeal is more limited in arbitration then in court, and other rights in court may be unavailable or limited in arbitration. Okay, so it looks like they're giving you some definitions here. Under this agreement, claims were subject to arbitration and all that good stuff. All right, so there we have two examples of arbitration. Now, one of them mentioned the AAA, and then this one right here, arbitration procedure is through, let's see, arbitration procedure, this one's through JAMS. Okay, all right, the arbitration will be administered by JAMS. All right, so you have to reach out to these people and you can get the rules and procedures on how to file your claim. Now, I have the manual already pulled up here for the AAA. Okay, you can go online and you can download this. All right, and this will answer pretty much any questions you have. And people, don't be afraid to reach out to these people and send them an email. They're very friendly and they will tell you exactly what needs to be done and how you can go about this. All right, so here go all the rules and procedures. I strongly suggest you go through and look at all this. This is 51 pages long for this company. Excuse me. All right, and I'm just gonna scroll through this because I'm showing y'all. I'm just showing you. All right, then here go JAMS. Right, here go their requests. I got it pulled up. Their documents. Just fill in the blanks, pretty much. Tell them what's going on, and then upload your documentary proof. And they pretty much take it from there. Now, fees, minimum fees is around about $250. Sometimes you may have to pay for it up front and then you'll be reimbursed on the back end or whatever. But then the remaining fees is typically on the banks, okay, or the corporation you're going against. All right. And finally, I'm going back to the top of this. I'm going to go ahead and show you this little road map I pulled up here, okay, just to give you a overall view on process. All right, we have, this is from the AAA, the arbitration roadmap. They say filing and initiation day 1 to 15, arbitration selection 15 to 44, preliminary hearing 44 to 85. Then you have information exchange and preparation day 85 to 222. So this is just a duration so you can get an understanding on, you know, how long this will take and what steps. This is very detailed. Like I say, I strongly suggest you go download this information, y'all. It's free, don't cost you anything, especially if it applies to you. All right, so overall, looks like they got up to what, 288 days to complete the arbitration. Well, with that in mind, this is yet another video. I hope this has been of benefit for you guys who took the time to watch it. Don't forget to like and subscribe if you have not already, and I appreciate you for your time. Peace and blessings.